are awesome. Don't cut my commission and spread the love and all that. That was pretty good. Made me laugh this morning. So I appreciate that from Jenny. So for those of you who don't know me, my name is Patrick McQueen. I'm a real estate attorney here in Arizona. I've been doing this for 18 years now. Our firm handles all sorts of real estate related matters, whether it's real estate litigation, whether it's commercial real estate transactions. Chances are we've done it or can do it or are doing it. Before I dig into the landlord tenant stuff, and I do have about 4 or 5 updates that I want to provide for everybody, I do want to give a general update on 2 of the things that I'm being asked about quite a bit. And those 2 things, the first is the Homestead Law, the new Homestead Law. That's going to trip up a lot of people in connection with residential real estate transactions. And so if you haven't heard of what's going on yet, or if you need more information on the new homestead laws, I have a memo, I have whatever sort of information I can provide to you. I'm happy to do that. So in Arizona, prior to this new law going into effect, prior to January 1st, for the last 100 years, frankly, we've had a very consistent, very understandable homestead law. And basically it meant that if there's a recorded money judgment against you or against a homeowner, against their primary residence or their homestead property, well, guess what? There's no lien attached with that judgment. And that means that the homeowner could sell free and clear of that monetary judgment, of that money judgment against them. Okay, so there's no lien associated with it. They can sell free and clear up to $150,000. Great news for a lot of people, very easy to understand. And that's just how our homestead law worked. There was no lien associated with the judgment. Okay, they could sell free and clear of any lien that is typically associated with the judgment. Well, now what we have is the exact opposite of that. We have the reverse of that. Okay, so a new law went into effect January 1st, 2022. That new law basically says these are now liens, and these creditors are going to be paid at close of escrow. So if you have a residential real estate transaction where somebody has a judgment against them, this isn't going to apply in the commercial world, doesn't work in the commercial world. But if somebody has a recorded money judgment against them, then we start to look at these new rules and these new laws, and chances are, if there's enough in proceeds, the creditors are now going to get paid, whereas very previously they didn't get paid. So it's a very, very important change to our laws, and it's going to trip up. It's going to create probably some more bankruptcies. It's probably going to create quite a bit of litigation as well. Now, I don't think it's going to do anything to change the market or do anything crazy like that, but it's just something to keep in mind. It's out there and it's happening. It's already tripped up some folks as well. And again, yep.
Can I pause you for a second? So
sure.
I think the homestead law just changed $150,000 to $250,000 as of January 1st of this year. And now the law also changed again that is not the case anymore.
Well, yeah. So yeah, very good. Yeah, very good. So what you're talking about is the exemption amount or the protection amount. It was $150,000 for a while. It went up to $250,000 under this new statute. And now, because there's so much irritation with this new statute and how it's going to work, they're trying to get it back to where it was and to have this much more understandable statute. So it sort of remains to be seen what's going to happen with the statute, but you're exactly right. The exemption amount went from 150 to 250. And now, as you said, there's a lot of folks who are not happy with the application of that statute, and it may go away. There are a lot of people are hoping that it goes away. So great point there. Appreciate that. The other update that I'm being asked about is in connection with short-term rentals. And, we've seen the city of Scottsdale, town of Paradise Valley have created their own new rules, and they're trying to implement their own new rules. In 2016, Governor Ducey came up with this very broad statute. And this very broad statute said, listen, cities, towns, municipalities, you have no say in how short-term rentals are going to be governed. You can't create zoning laws. You can't have licensing requirements. You're stymied. The laws come at the state level, and there's nothing you as a town or city can do. And we've seen now the town of Paradise Valley is trying to poke around that. We've seen city of Scottsdale now trying to poke around that a little bit. And they've been somewhat successful. But now there are two bills circulating in the Congress of Arizona Congress. And those two bills would actually repeal what Governor Ducey did in 2016. So there's two bills right now that have been circulated. I have them written down in case anybody wants to look at them. It's House Bill 2069 and Senate Bill 1026. And those would repeal what Governor Ducey did in 2016. And what that would do, or what that would have the effect of doing, is it would significantly give a lot of power to the city of Tempe, the city of Phoenix, whatever municipality or town didn't have authority or didn't have the power before because of the 2016 law. Well, now they're going to have the authority, and they're going to be able to create zoning laws. They're going to create their own sort of regime when it comes to short-term rentals. That's going to have a big effect on people wanting to buy, on selling, et cetera. And I think that has some a potential to be pretty interesting for our state, because it's a complete, reversal of the laws that currently exist. And so I would keep an eye on those two things. I think the homestead is a big one that we're going to keep an eye on. I think the short-term rental statutes for sure are pretty important right now as well for our economy, frankly. Now,
Patrick,
yep.
is there a website for those for those information that we can access and follow?
Yeah, it's hard to get those bills. There's actually there's a legislative website. It's the Arizona legislative website, and you can go in and track the status of House Bill 2069 and 1026. And there hasn't been a vote on them yet. They were introduced in January. And I don't know the name of the website that I use. It's called like Legiscan or something like that. And it gives you access to who's in support of these bills and who doesn't like them and when they were introduced. Let me see what I can do. I'll take down your contact information or something and get you a link to those, because I don't have direct access to that website at the moment.
And I also heard that for the public to join the meeting, to voice in and vote and stuff like that. That would be nice if you have information to share.
I do, and yeah, there's a public forum option on this website that I use, and I'll get you that. Maybe shoot me a message in the chat and give me your email address, and I'll shoot you the link that I have and the passwords that I have.
Okay, thank you so much.
Yeah, my pleasure. Okay, so on to the landlord tenant stuff, and again, a lot of this is going to apply to investors, owners, landlords, etc. So this is going to cover a fair amount of people, but we're going to talk about 4 or 5 things here. We're going to talk about the status of evictions and how to navigate, what we found were people who, we still find this, people who are stuck with not understanding, well, do I have to honor some sort of lease rights that my tenant has? Is there still a moratorium? Is there still these tenants' rights that existed, back in a year ago? And so we still see a lot of confusion, or a lot of people who got stuck. And so what I'm going to do is kind of go through a couple of different scenarios that'll get you unstuck. We're also going to talk about a new Court of Appeals case that came down dealing with residential evictions. We don't get a lot of appellate court decisions. Appellate court laws give us our laws. So we get our laws in Arizona from 2 sources: statutes or case law. And it has to come from the Court of Appeals to be binding on other folks, okay, to be binding law. So we just got a new case from the Court of Appeals that deals with a couple of things for investors and for landlords. It's helpful. And then I want to give you some anecdotal some information on some of the trends that we're seeing. They're a little bit frustrating for a lot of folks, and we'll talk about those things. But those are about the 4 or 5 things that we're going to talk about. And so let's talk first about, what can you do as a landlord? What happened and where are we really at? And so what's the status? Is there still a moratorium? There's no moratorium. There's no moratorium here in Arizona. There's no federal moratorium. Now there are state and city moratoriums in other states and other cities throughout the United States, but there's nothing here. But that doesn't mean a lot of people didn't start the process. start accepting payments and then not know now where they're at. What we saw and what we continue to see, a lot of people who are sort of stranded in the process still, even to this day. And they want to know, well, what do I do next? Okay, so some courts were issuing judgments for non-payment, but they wouldn't issue a writ of restitution. The writ of restitution is actually how you forcefully get these tenants out. Okay, so you get a judgment against them first. And then if they still don't leave, if the tenant still doesn't leave, then you have to apply for what's called a writ of restitution. You can usually get that within 5 days. The writ of restitution says to the sheriff, these folks have been evicted. They need to be removed. Okay, but we saw people getting these judgments and thinking that the judgment was enough. And it's not. Okay. Some courts we saw were still not considering evictions for a very, very long time. They wouldn't even let you file an eviction action. This is again here in Arizona. Some courts were issuing judgments for non-payment of rent, and then payments or partial payments were made because somebody got some sort of governmental assistance. What do you do when you get a partial payment or a full payment? What does that eviction go away? And then again, we just saw a number of people who were stuck and are still stuck. Okay, so here are the 3 rules that we've kind of come up with that may be helpful to some folks. So the first is, if the court has not issued a judgment for non-payment, but a lawsuit was filed. So let's say that somebody did file a lawsuit, 5-day notice was issued, lawsuit was filed, but there was no judgment. Well, then what needs to happen is that landlord needs to request a hearing and get the judgment and then obtain the writ. Okay, so we saw some people who filed lawsuits, but then they didn't go anywhere, either because the judge said no, or because landlord or the tenant paid something and they're sort of in limbo. Those cases need to continue to be moved through the system. Okay, and the way, if you're a landlord, to move that through the system is request a hearing, get that judgment, and get that writ. Okay, in some instances, the courts issued a judgment for non-payment, and no changes needed to be made. Okay, and all you have at that point is the judgment. Okay, we talked about this a little bit when I first started introducing this topic. If you have that judgment, okay, and nothing needs to change, all you have to do is apply for the writ. Even if the judgment's a little bit old, all you have to do is apply for the writ of restitution. Okay. Now, if the court issued a judgment for non-payment of rent, and there was rent paid, or the rent was increased, etc., well, then the landlord needs to obtain another hearing, amend that judgment, and then get the writ. Okay. And one of the questions that comes up as well is, let's say that I have this judgment, and let's say that I have this writ. There was a 30-day waiting period if the landlord had a federally insured mortgage. Okay, that doesn't apply anymore. And there was also a pleading requirement. We had to include in the complaint for eviction whether the loan was federally backed or not. That's no longer required either. Okay, so that's really the status of where things are in court. The courts have largely pushed a lot of these things through. And so that's good. And so, if you're still stuck, or of somebody who's still stuck, well, going through those 3 rules is really what you need to do. Okay, and if you need a chart on this, I can send you a chart. It's kind of a flow chart that just says, if you're here, then this is what you need to do next. Okay, but those sorry, somebody.
Yes, yeah, I said yes, please do. Please do send those.
Yeah, I can get you those, no problem, for sure. I'll send them to Lisa as well, just in case my contact information doesn't come through. We'll get all of this stuff to her, and you can ask her for those. Okay.
Can I have a quick question, real quick?
Sure.
Yeah, so I heard that because of COVID and stuff, there's a lot of rules has been changed or banned or something like that because of COVID. So the example you gave out, could it be because of that? And in those cases, if the tenant said that, well, I couldn't make the payment because I got COVID, or my family member got COVID and I have to quit my job to take care. I mean, in those cases, don't they have to support their case with official documents to prove that they in the case?
Yes, but that's no longer the case. So they did up through October of 2021, and they would have to attest and sign an affidavit stating that. And sometimes the courts would require some additional information on that, but that no longer applies. and the obligation to substantiate, your situation, that those no longer apply. Now, I will tell you, and I'm gonna jump off a little bit of topic here. This is one of the sort of updates, the anecdotal updates, and I wanted to talk about something else, but you brought this up. We're still seeing, for the last year and a half, and into 2022 now, we are still seeing a lot of sympathetic judges. Okay, and so let's say that you go through the eviction process and you want to evict somebody, and you get this 5-day writ or what have you, and you're saying to the judge, I want them out of my house, and they, or I'm the property manager, and we've got a new tenant coming in. Well, a lot of judges will specifically ask the tenant, do you need more time to move out? And that's never happened before. Never. I've never seen that happen except for in the last 6 to 8 months, maybe the last year. And so a lot of the judges are now seeming to be a bit more sympathetic to the plight of the tenants. And I think that's because of COVID, sure. Particularly if somebody's sick and they want to give folks an opportunity to get better. But I also think it's because there's nothing on the market. There's nowhere for a lot of these folks to go because the rents are getting higher, and there's just not a lot of availability. And so I think it's a combination of two things. And I wanted to make sure I brought this up because this doesn't really, it's not the law. The judges don't have to do this, but that's what we're seeing. We're seeing a lot of sympathy towards tenants that we've never seen before. And there's folks that want to change some of the laws when it comes to evictions. They want there to be more of a mediation process as part of an eviction. So there's some legislation that I know is proposed. I don't know if it's gone anywhere yet, but it would require that landlords and tenants actually sit down and have a discussion about the non-payment or certain issues, as opposed to just jumping to court. Again, I don't know if that's going to go anywhere, but again, to your point, there's been quite a lot of sympathy that's been given towards tenants. And I think that's a result of COVID. I think that's a result of the, not having much on the market. And as a part of that, in connection with filing a lawsuit against the tenant, the landlord has traditionally been entitled to attorney's fees, an award of attorney's fees. And those attorney's fees can range anywhere from, depending on how long the process takes, $1,500 to $5,000 if there's an actual trial. And what we're seeing are judges who basically say, I'm not awarding attorney's fees because of the plight of this tenant, because the tenant had a good enough excuse or a good enough reason not to be paying the rent, that I'm not going to award attorney's fees. I'm not going to award past due rent. And so a lot of these judges, again, are very sympathetic to the situation, more so than I've ever seen. And, it's hard to tell, a landlord client, hey, you're going to be able to get them out, but it's not going to be on the time frame that you were thinking or the time frame that the law allows. So again, I that's part of the anecdotal stuff that we've seen. There's no law behind that. I suppose the judges can use that discretion, and they're certainly using it. So just, if you run into a situation and that pops up, I don't know what to say other than it's happening everywhere. So we also had a case that came out not too long ago, towards the end of last year, pertaining to evictions and pertaining to the Landlord-Tenant Act and pertaining to investing in these types of transactions as well. Okay, so this is the Ibarra case, and again, we get our law from two places. We get our laws from the statutes, or we get our laws from case law. This is a Court of Appeals case that came down. And it doesn't have anything to do with the CDC moratorium. I suspect we're going to be having cases that come down from the Court of Appeals that dealt with the CDC moratorium or even Governor Ducey's moratorium. But this one has nothing to do with that. These types of cases take a little bit of time to work themselves out. This is the Ibarra case, and it really stands for two propositions. So let me give you a couple of facts. Tenant stubbed his toe on a crack in the tile. And tenant said, look, I've complained about this to the landlord in the past. Landlord never did anything. I stubbed my toe again, and now I've got medical bills. Okay, and I want the landlord to pay my medical bills. right? Tenant turns around and sues the landlord under the Landlord-Tenant Act. And on the complaint, it says breach of Landlord-Tenant Act. And the Landlord-Tenant Act, as we know, requires that a landlord keep the property in a fit, inhabitable condition. That's this general standard, okay? And the tenant argued, hey, I stubbed my toe and hurt my toe, and this is an automatic violation of the Landlord-Tenant Act, and I'm entitled to collect damages, and I'm also entitled to get out of the lease. Well, the court actually said, no, you can't sue under this broad Landlord-Tenant Act. You can't say, I'm suing you under the Landlord-Tenant Act. You might be able to sue for negligence, but the Landlord-Tenant Act does not create its own standard of care. It has these general requirements that we're all required to abide by as landlords or property managers, but it doesn't give rise to a private cause of action for damages or to get out of the lease, okay? And so that was good for landlords. I think that was a good resolution for landlords. But I think more importantly, what it said was, so this particular tenant sued the landlord as the landlord as an LLC, and they sued the landlord, the owner of the LLC, the owner of the property individually, okay? And so normally, if you have a landlord, if you have an LLC, you shouldn't be sued. You really can't be sued unless you've, commingled funds or commingled assets or whatever. In this particular situation, the tenant sued this person individually and the LLC. And the court in that particular situation said no as well. We're going to respect the power of an LLC. The purpose of setting up an LLC is to avoid personal liability. We're not going to allow for personal liability in this particular situation. So that's good for landlords. What it stands for, and frankly, there's eroding protection in other states, but what it stands for is that landlords have protection if they operate through an LLC, okay? Even if it's a single member LLC, you've got protection if you're a landlord, okay? And so that's pretty big. And so for folks who are doing stuff in their individual names, this is a word of caution here. Set up an LLC, convey the property to an LLC, and chances are you're not going to have any personal liability, okay? And that's what this case stands for. So it stands for two propositions. Number one, you can't just go and sue under the Landlord-Tenant Act. You can't just go and say you've breached the Landlord-Tenant Act. I'm now going to sue you. You have to sue for negligence if there's an injury, that type of thing, or premises liability. But more importantly, I think is the case for investors. For those folks who are single member LLCs, I think there's now protection. Now in other states, Colorado, some cases in California seem to indicate that if you have a single member LLC, if I'm the owner of my LLC, I'm treated as one and the same as the LLC, okay? Meaning that I have no protection, meaning that my LLC really doesn't do much for me, okay? And the court here in Arizona said, no, we're going to recognize single member LLCs as having powerful protection, okay? So that's a good thing. Now, one of the other things that I will note that sort of came anecdotally as well. If you have an LLC and you're wanting to evict a tenant, okay, you as the owner of that LLC probably cannot do that on behalf of the LLC. What I mean by that is, let's say you own an LLC and you're a landlord and you want to evict your tenant. You probably have to hire an attorney to do that. Okay. And the reason I say that is because if you're out there acting on behalf of the LLC, if you're out there acting on behalf of a corporate entity, which is what you're doing if you're evicting somebody, which is what you're doing if you're filing this action, there are some courts in Arizona that will say, no, you can't do that. That's the unauthorized practice of law. You individually could represent yourself if you own this property individually. But now that you own this through a corporate entity, now that you own this through an LLC, you're representing another entity. You're representing a company. You can't do that. That's the unauthorized practice of law. So you have to hire an attorney in that situation. So it's kind of this circular argument, but anecdotally, we've seen a lot of courts who are kicking these cases out, who are saying, you as the owner of the LLC can't maintain this action because you have to have an attorney do it. All right. And so I don't know if that goes into the sort of sympathy thing that the judges are doing, but they're kicking a lot of these cases out. They're requiring that people refile these with an attorney, and then they're not giving the attorney's fees. So it just becomes it's evictions have somewhat become a bit of a mess lately. So that's all I have. I wanted to make sure that you guys have the status of where things at. There is no moratorium. Depending on where you're at in the process, you have a couple of options, a couple of things you can do. There's the new case that I mentioned about the gentleman who stubbed his toe, which really stands for the proposition that there is protection if you have an LLC and you are a landlord. Okay. And then there's the unauthorized practice of law concern. Again, that one comes up every once in a while. And then the fourth thing is this fees issue, right? The attorney's fees issue under the lease, under any written lease that you have with the tenant. If there's a contested action, the law says you're entitled to an award of attorney's fees. Again, these judges right now are cutting those significantly. And so you just have to know those things. So I would say that those are the top four things that we've been dealing with in eviction land, in residential eviction land. I'll open it to anybody who has any questions. And again, I've got some emails that I'm going to send out on the homestead exemption, short-term rentals. And if anybody wants the flow chart or anything else, just let me know. Does anybody have any questions that I can answer?
Yes. Hi, Patrick. So you brought up a lot of good things that I don't think I learned about them all. So even you mentioning, like, even if in the lease we have a statement saying that lawyer fee and court fee will have to be paid by the tenant if there is any contested issue. So even if we have that in writing in the lease and the tenant side, the judge still don't approve it.
Yeah.
I mean, that's against the law, isn't it? Because it is in writing with the agreement, with signature. So I mean, the judge have to make sure everybody follow what's in writing, correct? Otherwise, it's
it can be very frustrating because sometimes what we'll see is that provision. So in addition to including it in your contract, which you should, and it's in the standard form Arizona Association of Realtors contract that says if there's a disputed matter arising out of this lease, the prevailing party, if we have to go to court, the prevailing party is entitled to an award of reasonable attorney's fees. And there's a statute that says almost the exact same thing in Arizona. Mm-hmm. So there's a statute, it's ARS 12-341, okay? And what that statute says is, in a contested action arising out of a contract, the prevailing party is entitled to an award of attorney's fees. Okay, so you would think then I get my attorney's fees, you know, in almost all situations. And maybe you do, right? Maybe you do get these attorney's fees, but the court has the discretion and they're going to utilize this discretion. And they've been utilizing this discretion to reduce those. And so, yeah, it can be very frustrating because perhaps, you know, you have this attorney's fees bill that's $2,500 and you're never going to see a dime of it. And so it's very frustrating. And so you just knowing that going in, like, I just have to tell people right now, there is a trend towards judges who want to, you know, wipe away those fees.
I mean, yeah, it doesn't sound, you know, right. If they have it in the rule, that's one thing. If they don't have it in the rule, but both parties have it in writing with the agreement, the judge should not break the rule. I mean, if he's rule against that, to me, he break the rule.
Trust me, I agree with you.
Yeah.
But you know, who am I can't really question that. I don't. All I'm saying is, yeah, I agree with you. I don't know what to do about it, though.
Right. I mean, there must be a court of appeal or some higher power to come down and to look at the situation. I don't think it's right. I mean, if they don't have it in writing, that's one thing. But if they have it in writing, yeah, then that's.
I would agree with you. And so what I think that the courts are trying to do is they'll reduce it. And you have the right to appeal that award, right? You have the ability mm-hmm. to appeal the amount that the judges awarded you. But I think in most of these instances, the courts basically say, look, you know, it's going to cost this person more to appeal it than they're ever going to get in these attorney's fees. So they're probably not going to appeal it. So I'm just going to reduce the award, and you know, hopefully they'll just live with it. And so, you know, a lot of people aren't going to appeal that to the Court of Appeals, even though it's definitely an issue that should be addressed by the Court of Appeals.
Right. And you brought up another issue that, you know, rent is so high now, and then the supply is just so low. That sort of thing is create a congestion. And also, you know, the rent amount is so high. I mean, it went up like 25% or something compared to last year. So with that kind of amount of rent that people, if they don't pay and they have to be evicted, just imagine, you know, how much of money the landlord can, you know, can lose out if, I don't know. I mean, the way, if that is a trend nowadays, they're just gonna do that. I think it's gonna create more issues. Because landlord, if they lose out so much in one deal, they're gonna try to recoup it in the next deal, you know. So they're gonna raise the rent higher. I don't know. That to me, that's just natural common sense, right?
Well, and I get a lot of questions.
Mhm.
Hey, my landlord's raising my rent. It is, you know, by 10% or 15% or 20%, you know, a big raise.
Mhm.
Can they do this? And the answer is yes. There's no law that says they can't do that. And if they're able to get the rent, you know, then they're able to get the rent. But there's no law that says they can't, or there's a cap on how much you raise it.
Exactly. In Arizona, there's no cap. I mean, I don't know. I think typically people try to be reasonable to each other, but when it gets to a case where they have to evict, they have to sue, and they have to, you know, but just have to be fair and square. I mean, if he not, he leaning toward one side and favor one side without a really good reason, it's gonna create issue down the road, you know, in the market. I don't know if the judges see that.
No, I think your point is very well taken. I agree with you. I
Yeah.
definitely agree.
All right. Well, thank you so much, Patrick. I don't have more questions, but can we have your email or some way to
Oh,
contact
yeah, that's
you?
great. Let me, yeah, for anybody who wants any of those charts or anything else, I'm gonna put my contact information in here in the chat so you guys have it. And I'm happy to get those. I'll also forward those to Lisa, but here's my contact information. I'm gonna give you my direct number as well. Say 283. So it's patrick@mnglawgroup.com, and then my phone number is on there as well. Well, hopefully everybody's having a great 2022, and if there's no other questions, I think we can probably sign off, Lisa.
That sounds good. Thank you again, Patrick, for a very informative webinar for our members. We certainly appreciate it. A lot of information, and let me know, send information over, and I'll be happy to send it out. Then anybody that would like to have it, that would be just fine.
Yeah.
All righty.
Thank you so much. Yeah. We
Thank
put
you.
our email in the chat here. Hopefully you have a chance to capture them. And we would like to receive your material, Patrick. It's very helpful.
Perfect. Well, thank you so much for saying that. I appreciate it.
All right. Have a great day, guys. Bye.
You too.